This episode is brought to you by the new true crime docuseries American Nightmare, only on Netflix. In 2015, the Vallejo, California Police Department received a strange phone call about a kidnapping. But when the truth is stranger than fiction, you won't know who to trust or what is real. A fast-paced true crime thriller with cliffhangers at every turn. Watch American Nightmare now, only on Netflix.
In the last episode, we heard from one of Bryan Patrick Miller's friends, who described what Miller's home looked like at the time of his arrest, and what Miller said to him from behind bars after the arrest. Now we're focusing on strategy, the strategy aimed at keeping Miller alive, and the one used to call for his death if he's convicted.
Competency and insanity are different.
The simple fact of making a murder case a capital murder case will add layers of complexity.
And what is your opinion on the issue?
I don't believe that he is competent to stand trial.
This is True Crime Arizona, the Zombie Hunter.
It's January 2015. Bryan Patrick Miller has just been arrested for the Canal murders. It was time for him to make his initial appearance in front of a judge. Video shows him slowly walk up for his turn, wearing his black and white striped jail suit and his glasses.
Bryan Patrick Miller, October 24th, 1972.
Is there anything that you want to say at this time? You do not have to say anything.
Very, very quietly, Miller mumbles back, "No, ma'am." The judge then continues.
This court is going to hold you without bond on the basis of the 2 murder charges and the 2 kidnapping charges and the fact that you pose a substantial danger to the community, which is so great that there is no reasonable release condition that could assure the safety of the community.
No bond. Bryan Patrick Miller would remain behind bars until his trial began. And that's where this part of the story picks back up. Often, with trials of this magnitude, it can take years to begin. But the wait for Miller's trial has been longer than most. 7 years and counting.
It's a long time. I don't think it's terribly unusual in this particular case. These kinds of cases usually take a long time to get to trial.
Russ Richelsoff is a criminal defense attorney not connected to the case. So we asked him to sit down with us and break down the oddities and important details in the case. The trial was supposed to start on September 21st, 2021. Then things changed. Why? In part because of the original decision for prosecutors to seek the death penalty. Morgan is going to get into that in a few minutes. But another reason has to do with the defense team's tactics. Bryan Patrick Miller's defense team claimed insanity as a defense and claimed he was not competent to stand trial.
And what insane means in this context is that they could not understand the nature or wrongfulness of their actions at the time they committed the offense. Competency and insanity are different. You can be insane and incompetent. You can be sane and not competent. So they're actually 2 mutually exclusive things. In this case, obviously, the time component is at issue. Competency is concerned with his mental health now. Is he capable of effectively communicating with his lawyers? Does he understand his constitutional rights? Does he understand the proceedings? Does he understand the role of the judge, the role of the prosecutor?
It's now January of 2022. We had been waiting for decisions from the judge. Then, a huge update. Bryan Patrick Miller was found competent to stand trial. In the ruling on Miller's current mental fitness, the judge wrote, quote, "Other than the claimed inability to remember the charged offenses, defendant presently has a rational understanding of the charges against him and the nature of the proceedings." The defense had hired an expert doctor to look into Miller. His name, Dr. Richard Frederick.
Richard Frederick, RICHARDFREDERICK.
Thank you. Raise your right hand, please. You do solemnly swear the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
We were able to get audio of this hearing and Dr. Frederick's testimony. The defense attorney speaks first.
What question did we refer to you to get you involved in this case?
You asked me to evaluate Bryan Miller's competency to stand trial for the charges against him.
Do you offer a specific opinion as to whether you believe Mr. Miller is competent or not?
Yes.
And what is your opinion on the issue?
I don't believe that he is competent to stand trial.
In terms of your opinion that Mr. Miller is not competent to proceed the trial, what might be the most important factor weighing in your analysis that he is not competent?
Well, I think the most important element is that he cannot assist his defense in a number of ways if he has a dissociative amnesia, which I think it is more likely that he does have a dissociative amnesia than he does not. If he has it, he simply cannot provide the information in many ways that I've articulated in my report to offer the defense of insanity. He just, you cannot effectively present that defense because he is effectively absent on the issues that you need to address to persuade a jury or a judge that he was not criminally responsible for his actions.
According to the Mayo Clinic, if a person has dissociative amnesia, their main symptom is memory loss that's more severe than normal forgetfulness, and that can't be explained by a medical condition. The person can't recall information about themselves, of events or people in their life, especially from a traumatic time. Dr. Frederick explains why he thinks Miller has this disorder to the judge.
The knowledge that he had abuse as a child, that it was reasonably construed as severe, gives plausibility to the idea that he has dissociative amnesia and other dissociative disorders. These are common responses to severe physical, emotional, and psychological abuse. My interview with him was specifically intended for me to get a sense of whether he might be faking amnesia or a person who was likely malingering his presentation. And it was important for me to lay eyes on him, to interact with him, to engage with him, and to have some impression of whether this was likely best explained by faking or malingering, and also to evaluate whether there was probably a way to assess that.
Here's where this got real interesting. Bryan Patrick Miller himself was annoyed that a doctor could think he had that disorder. He wants to stand trial.
He's offended by the idea that he might be dissociating or have amnesia for something he claims he didn't do.
The other factor that played into the judge's ruling was that Dr. Frederick could not rule out that Miller was faking a mental disorder. And based on the reports of two other doctors hired by the state, the judge deemed Miller psychologically competent to stand trial. However, she did not rule on the other part of all this, the insanity claim. The second Russ Richelsoff started looking into this case with us, it was already a case unlike any other, which will lead to an unprecedented trial for a few reasons.
There's a lot of interesting issues in this case. The first and the most obvious one is the forensic genealogy. You know, are we going to see a rash of cold cases getting solved because somebody's cousin went on, 23andMe and posted their DNA, profile? So that in and of itself is very interesting. The other thing about this case, which is very interesting, and it didn't occur to me at first, and then I started doing the legal research on it. When a crime is committed and somebody is charged with that crime, the law that applies is the law that was in effect at the time the crime was committed, which in this case was, almost 30 years ago. The law has changed considerably since these crimes occurred.
This detail could have major implications on the outcome of this trial if a judge does deem Bryan Patrick Miller mentally insane.
The law now in Arizona and most of the United States with regards to insanity is this concept of guilty except insane. Sometimes you'll hear people refer to it as GEI, guilty except insane. And what that means is the person is found guilty, meaning the prosecutor has proved the elements of the offense beyond a reasonable doubt, and the defendant has proven by clear and convincing evidence that they were insane at the time that the offense was committed.
That basically changes the location that the person serves time.
What would happen in a modern case if somebody did the insanity defense? It's not really a defense anymore. It changes how the person is sentenced. So one big change is it's if somebody is found guilty except insane, it's not considered a criminal conviction. The other big difference is that rather than getting sentenced to prison, the person would be held in a secure mental health facility. So essentially, the person would go to a mental health facility to be, one, to keep the community safe, but two, to receive treatment. But with this case, what's really interesting is this is a not guilty by reason of insanity case. This case is going to take place under the old law, the laws that haven't been in effect for almost 30 years.
Because of the laws in effect in 1992 and 93, when Angela and Melanie were killed, if the judge does find Bryan Miller insane, Richelsoff says this is what would happen.
Even if the prosecutor proves beyond a reasonable doubt that this person committed these crimes, if the defendant proves by clear and convincing evidence that they were insane, they did not understand the nature and wrongfulness of the acts at the time that they committed them, then they're essentially not guilty. They get found not guilty. Rather than getting placed in the secure mental health facility for a specific term of time like you would if you were sentenced to prison or held in a secure mental health facility under the modern statute, they would be subject to review. It's about every 6 months. There would be a review to determine if this person is still suffering from this, mental illness or mental defect. If they were required under the criminal statute to serve 20 years in prison, they would be placed in a secure mental health facility for 20 years. Under the old statutes, it's reviewed, like I said, about every 6 months.
This all means if Bryan Patrick Miller is found insane, even though he is found to have committed the murders, it's a not guilty verdict. And instead of having a set sentence time he'd have to serve in a mental health facility, he would be reviewed every 6 months in the facility. If he is deemed not insane during any of those reviews, Richelsoff says he could be set free. Based on evidence in this case, it's been easy for people in the community to say, oh, I'm sure he's going to be found guilty. But Richelsoff says even if it appears black and white, it isn't.
Or even when I think I have a strong case, I'm a defense attorney, even when I think I have a good defense, I've got a likable client, I think I can win, I'd never put my odds at greater than 50%. because there's so many things that can happen in a trial that you just can't predict, you just can't control for. You know, the prosecutor is going to probably try to portray him as a weirdo. You know, hey, here's what this person was into, that's really weird, they're not like us. You and I don't do those kinds of things, that's weird. You know, the defense is going to portray it exactly like, you know, you'd like to dress up for Halloween. This is what he liked to do on the weekends. It was, you know, some harmless fun. It's easier for the jury to convict somebody if the jury doesn't identify with them.
Here's where I'm going to pick up the story, because although delays from COVID played a role, the real elephant in the room when it comes to how long it is taking for this trial to take place is the death penalty. I want to make something clear here. This is not intended to be for or against capital punishment. But the reality is that death penalty cases take a long time. A long time. And the initial trial, that's just the beginning.
There's no question about that. The simple fact of making a murder case a capital murder case will add layers of complexity to the pretrial proceedings, to the trial, to the appeals. It will make it much more time-consuming. It will make it much more costly, and it will make it much more prone to error and reversal.
That is the voice of Robert Dunham. He is the executive director of the Death Penalty Information Center. This nonprofit organization provides information and analysis on death penalty issues, but does not take a stance for or against the death penalty itself. That being said, Dunham did tell me that he is critical of the way in which the death penalty is carried out.
Is the death penalty, in your experience, used the correct times in the correct manner and carried out correctly across the country?
Well, it's hard to make an assessment of what the correct usage would be. But all the data shows that the death penalty is geographically arbitrary in the way that it's imposed. It's arbitrary in the sense that if I gave you a list and I read you the facts of cases, and then I gave you another list and I read you the facts of those cases, and I asked you to tell me which one resulted in the death penalty and which one didn't, you wouldn't be able to do it, and I wouldn't be able to do it either.
According to Dunham, and he has studied these cases, the death penalty is also arbitrarily applied in serial killer cases, meaning even in the most heinous cases with multiple victims and especially cruel or depraved manners of murder, you still would not be able to tell which killers received death and which ones got life in prison.
With serial killers like the Green River killing, there were 48 people who were killed. And what was the result? No death penalty. And it was no death penalty because prosecutors were trying to get additional information and gave up the death penalty in order to find another dozen or so bodies. Very recently in California, you had the Golden State Killer. And you're looking there at 13 rapes and murders. And the outcome there was we're dropping the death penalty. So you can no longer say that that the death penalty is consistently imposed in some of these really horrific cases, even if it is something that most people would say might be justified.
That brings up an important point in the case against Bryan Patrick Miller. That is, that not everyone supported the prosecutor's decision to seek the death penalty against him. For example, Angela Brasso's boyfriend from back in 1992 sent us a message stating, "If Miller is proven guilty, I hope he doesn't get the death penalty. Why, you ask? If he is put to death, it's over for him. Life in prison would let him experience missing out on all the experiences his family will have, just like Mrs. Brasso, She never saw another birthday for Angie, never saw her get married, and so on. I think it's more fair for Bryan to live with that than die in peace. There are other reasons people involved in this case opposed the death penalty. Remember that Miller is suspected in other attacks. Police even requested that prosecutors charge him with Brandy Meyer's murder. They turned that request down, but Meyer's sister, Kristen, told us she would rather see Miller confess to the crime and receive life in prison than have him die, never knowing for sure if he is the killer. That is a debate that Dunham says prosecutors struggle with in these types of cases, especially because county attorneys and district attorneys, the ones who make the decisions to pursue the death penalty, those people are elected.
Experience has shown that that voters will not hold it against a prosecutor if the prosecutor has acted compassionately towards victims' families, and as a result of that compassion, not sought the death penalty.
Is the notoriousness, the newsworthiness, the headline aspect of a case, does that play a role in prosecutors seeking the death penalty in your experience?
Disproportionately, yes. What we see across the board is that the death penalty is disproportionately pursued in favored victim cases. And if it's a victim that we care about, either because of something of the characteristics of the victim or the amount of publicity that a case gets, it is much more likely to result in a capital trial.
Finally, one of the most significant downsides of seeking the death penalty, according to Robert Dunham, is that these cases have a disproportionate chance of getting reversed on appeal.
The death penalty has been imposed more than 9,500 times since capital punishment came back in the 1970s. There have been 1,540 executions, which means that most of the time the death penalty does not result in an execution. Most of the time, the outcome is the death penalty is overturned and then either dropped, or on retrial, the defendant gets a sentence of less than death.
We do not know what will result from Bryan Patrick Miller's trial. We know that the pre-trial process has dragged on a long time. We know that it looks like the defense team has looked into a lot of Miller's life and history, looking for a way to keep him from standing trial or to potentially save his life if he is convicted.
And we know the prosecutors believe they have a strong case, at least in the Brasso and Burness murders. We may never know if Miller is responsible for other attacks because he's not talking, and at this point, he has no incentive to. True Crime Arizona: The Zombie Hunter is hosted by me, Brianna Whitney.
And me, Morgan Lowe. Sergio Hernandez is the producer.
It's a production of Arizona's Family, CBS 5, 3TV, and azfamily.com in Phoenix, Arizona.